Welcome to Lawminds. Now I am going to explain false evidence. Section 191 to 197 and 208 to 212 of Indian Penal Code. The Indian Penal Code's Chapter 11 addresses giving false testimony. The purpose of the testimony given in court is to convince the judge of the important details of the case. The two most common types of evidence are oral and written. It is vital to include the offence of using false evidence in the IPC, since the evidence produced in court will determine the outcome of the entire case. False evidence may be produced by the police, the prosecution in a criminal case, or someone who is sympathetic to either side during a case. For example, forensic job. Forensic job finds it simpler to fake evidence and test results than to perform the real task in question. The analysis of forensic evidence may also be fabricated. The particular reason for finding proof will differ depending on whether one side wants to win or lose in their argument or not. Even though it is intended to and may result in the conviction of the guilty, falsifying evidence to obtain the conviction of those honestly believed to be guilty is considered a form of police corruption. However, it may also reflect the falsifier's incorrect prejudices and tends to encourage corrupt police behavior more generally. Now I am going to explain offence related to false evidence, section 191 to 197 of IPC. Section 199 explains about giving false evidence. This section states that it is considered giving false evidence when someone who is required by law to tell the truth, either under oath or by an express legal provision, makes a false statement that they know to be false, believe to be false, or do not believe to be true. This is what section 191 explains about. And the essential ingredients of section 191 are: a person must be legally bound by an oath or any express provision of law to state the truth or to make a declaration on any subject. And he must make a false statement. And he must be aware that such statement is false. And he must believe that it is a false statement, but he still gives such statements. These are the essential ingredients of section 191. And the essential prerequisite condition for the application of section 191 are: he must be under a legal obligation to state the truth, and he must make a false statement or declaration, and he must believe that it is false. These are the prerequisite conditions to apply section 191. Now section 192. It speaks about fabricating false evidence. Anyone who creates a circumstance making a false entry in a book, record, or electronic record, or creates a document or electronic record containing a false statement with the intent that the circumstance's false entry or false statement may be used as evidence in a legal proceeding, in a legal action, a public official, or before an arbitrator, the circumstance, false entry, or false statement as used as evidence may be used against them is guilty of the crime. The essential ingredients of section 192 are: the accused caused certain circumstances to exist or be made false entry or made or fabricated a document containing false statement. And the next one is: he intended to use it in some judicial proceedings or in a proceeding before an arbitrator. And the authority conducting the proceeding on the basis of such fabricated document may form an opinion on the said document. And the accused intended that an erroneous opinion to be entertained, and such opinion should touch upon the material result or the proceeding. Section 193. Section 193 speaks about punishment for giving false evidence or fabricating false evidence. Any individual who deliberately gives false evidence in any court proceedings or furnishes false evidence with the motive of using it in court proceedings will be penalized with imprisonment of either description for a term that may extend to 7 years and be liable to a fine. The essential ingredients of Section 193 are: the accused was legally bound to state the truth, either by an oath or of an expression provision of law. Next one is: the accused must have made the declaration in question, and such declaration or statement was made in a stage of judicial proceeding. The statement or declaration so made was false. The accused know it to be false or believed it to be false or did not believe it to be true. The accused made such false statement intentionally. Section 194. Giving or fabricating false evidence with intent to procure conviction of capital offense. Anyone who provides false testimony with the intent to convict someone of a crime that is punishable by death under Indian law currently in effect, or with the knowledge that he will likely to do so, faces a life sentence in prison or a term of rigorous imprisonment that may last up to 10 years as well as a fine. The essential ingredients of Section 194 are: accused gave or fabricated false evidence. He did so intending to cause or knowing that it will likely to cause the person to be convicted of capital punishment. And the capital punishment passed was executed. The person who suffered the execution was innocent. Now Section 195. It is giving or fabricating false evidence with intent to procure conviction of life sentence. Giving or creating false evidence with the intent or knowledge of committing a crime that carries a 7-year minimum sentence or a life sentence. Such person will be punished in the same way as someone found guilty of that crime would be. The essential ingredients of Section 195 are: all the ingredients of Section 193 must exist, and while giving or fabricating false evidence, the accused must know that the person is to be convicted of an offense punishable with imprisonment for life or imprisonment for 7 years or more. Section 195A. Giving or fabricating false evidence with intent to procure conviction of life imprisonment. Anyone who threatens another with harm to their person, reputation, or property, or to the person or reputation of anyone in whom they have an interest, with the intent to coerce that person into giving false testimony, shall be punished with either a fine or a term of imprisonment of either description which may not exceed 7 years or both. The essential ingredients of Section 195A are: threatening or coercing someone to give false testimony, threaten to harm a person, reputation, or property, intention to coerce a person to give false testimony. Section 196. Using false evidence. Anyone who fraudulently presents or makes an attempt to present any evidence that they know to be false or manufactured as genuine evidence will be penalized in the same way as if they presented or made up false evidence. Essential ingredients of Section 196. The accused must present or attempt to present evidence in a legal proceeding or context. The accused must know that the evidence they are presenting is false. The evidence, even if not genuine, must be presented or created in a manner that appears to be genuine. Section 197. Issuing or signing false certificate. Anyone who issues or signs a certificate that is legally required to be given or signed, or that reflects to a fact for which such a certificate is legally admissible in evidence with the knowledge or actual belief that the certificate is false in some material respects will be punished in the same way as if he provided false testimony. The essential ingredients of section 197 are: the accused issued or signed a certificate. Such certificate was required in law to be issued or signed. It is related to admission of a fact. It is legally admissible in evidence. The certificate is also the certificate is false on material particulars. The accused knew or had reason to believe that it was false. Offense relating to false evidence, section 208 to 212 of IPC. Section 208 explains that it prescribes punishment for fraudulent sufferance of decree or order for a sum no due to him or for a larger sum than is due to such person, which is imprisonment up to 2 years, or with fine or with both. The essential ingredients of section 208 are: accused caused or suffered a decree or order to be passed or executed against him. Such decree or order as in respect of the sum not due or for a sum larger than is due or for an interest in which the decree holder was not entitled to or for the execution of the decree which has been satisfied. Section 209 dishonestly making a false allegation in court is punishable by up to 2 years in prison and a fine under section 209 of Indian Penal Code. The essential ingredients of section 209 are: the accused made a claim, he did it dishonestly or fraudulently or with the intent to annoy or cause harm to someone. He claimed in a court of law it was entirely or partially false. The accused knew it was untrue. Section 210. This section prescribes imprisonment up to 2 years, a fine, or both as a penalty for fraudulently obtaining a decree or order against any person for a sum that is not due or for a bigger quantity than is due. This clause allows for prosecution notes or bond papers. The essential ingredients of section 210 are: the accused obtained a decree or order in his favor. Such decree or order was obtained fraudulently. The decree or order was in respect of a sum which is not due or for a sum which is larger than actual dues alternatively. The essential ingredients of section 210 are: the accused voluntarily caused the decree or order to be executed against any person after it has been satisfied or for anything in respect of which it has been satisfied, or fraudulently suffers or permits any such act to be done in his name. Section 211. This section prescribes punishment for falsely implicating someone in a criminal case, which can be a sentence of up to 2 years imprisonment, a fine, or both. If the falsely implicating party is involved in a case where the penalty for the offence is death, life imprisonment, or a sentence of 7 years or more, the accused may face a sentence of up to 7 years of imprisonment as well as fine. The essential ingredients of section 211 are: the accused started a criminal investigation. The charge was untrue or there was no justification for the action. The accused knew at the time the charge was brought that there was no legal basis. Section 212. Section 212 defines that harboring an offender is punishable by up to 5 years of imprisonment or fine or both. If the offence is punishable by life, life imprisonment, or a term of up to 10 years, the accused is subject to a punishment of up to 3 years imprisonment or a term of up to 3 years imprisonment, a fine, or both. If the offense is punishable by death, the accused is subject to a punishment of up to 5 years of imprisonment or fine, or both. The spouse of the perpetrator who has been hidden or harbored is not covered by this provision. The essential ingredients of Section 212 are: the person who has harbored committed an offence, the accused harbored or concealed the offender knowing or having reason to believe that he committed the offence was punishable by death or life imprisonment, when the offence was committed in violation of any social or local law, the offence was punishable with a 1 year sentence. The act intended to screen the offender. Thank you. Please do like, share, and subscribe. Lawminds.